A very good morning to all. Today, we are going to discuss a very important case, the High Court dismissed a writ petition upholding the order in appeal, which had set aside the refund sanction order. The court found that both the transferor and the transferring companies, as well as the jurisdictional officers, failed to strictly comply with the statutory provisions governing the registration, cancellation, and transfer of unutilized input tax rate in the amalgamation case. The court emphasized that a refund is a statutory right requiring strict adherence to the prescribed procedures and applied to the doctrine of peri delicto due to the mutual non-compliances. The summary of the facts of the case is as follows. The impugned action, the Additional Commissioner GST Warada set aside the refund sanction order dated 28 Feb 2024. This order had granted a refund of around 2 crores of unutilized input tax rate to Alstom Rail Transportation Private Limited for the exports made in April 2023. The petitioner's argument, the petitioner, the amalgamated entity, contained that it had a vested right to claim the refund of unutilized ITC for zero rated suppliers as it existed and made the exports before amalgamation and registration cancellation. They argued that the Section 18, subsection 3 of the GST Act and the Rule 41 of the CGST rules are permissive, not mandatory, regarding the transfer of entire unutilized ITC, thus allowing for the partial transfer and subsequent refund claims. Further, they argued that the prospective cancellation of the registration by the authorities implies its continued existence until that date. The core question of the law, whether an amalgamated company can claim a refund of unutilized ITC retained by the dissolved transferor company after only partially transferring ITC under the Section 18, subsection 3 of the CGST Act and Rule 41 of the CGST rules, despite irregularity in registration and cancellation process following the amalgamation. The key issue before the court was to analyze the section 22, 25, 29, and 87 of the CGST Act 2017, along with the Rule 8, 20, and 22 of the CGST Rules 2017. In light of the amalgamation, the transferee registration obligation, section 22, subsection 4, mandates that the transferring company is liable to be registered from the date the registrar of the company issues the incorporation certificate. Application for the registration on 10 May 2023 before the NCLT order and ROC certificate and its retrospective registration from 25 May 2023 were de-honors the provisions of the Section 25 of the CGST Act 2017. Transferors cancellation obligation. The Section 29, subsection 1, Class A of the CGST Act 2017, read with Rule 20 of the CGST Rules 2017, requires the transferor company to file an application for the cancellation of its registration within 30 days of the amalgamation effective date 22 September 2023. Failed to do despite the intimating authorities on the 10th October 2023 and assuring the compliances. Suo motu cancellation powers. While the Section 29, subsection 1 of the CGST Act empowers the proper officer for the suo motu cancellation, assurance of compliance neglected the immediate need for such action. The court noted that the officer having knowledge of amalgamation was required to form an opinion and issue a show cause notice under Rule 22 of the CGST Rules 2017. Retrospective cancellation. The court rejected the petitioner's argument for the retrospective cancellation under the Section 29, subsection 2, as this subsection applies to a specific contribution, for example, fraud not relevant to the petitioner's case. Effect of Section 87, subsection 2, with its non obstinate class members, the amalgamated companies are treated as a distinct under the NCLT order dated, and their registration certificate shall be cancelled with effect from the date of the such order. The cancellation of the registration on the 29th November 2024 did not reconcile with the statutory mandate. Mutual non-compliances. The court found that both the companies, along with the respondent officers, apparently disregarded the statutory provision concerning the registration and cancellation. Interpretation of ITC transfer and the refund provisions. The court referred the Supreme Court decision in Union of India versus VKC Footstep India Private Limited, holding that the refunds are statutory prescriptions, not constitutional rights, and are subject to the legislative restrictions. Strict interpretation of this taxing statute, the court relying on the Chief Commissioner of the Central Excise and Services Tax versus the Safari Retreat Private Limited, reiterated that the taxing statute must be read strictly without additions or subtractions, and equitable consideration are out of place. Transfer of unutilized ITC, partial transfer impermissible, amalgamation effect on businesses. The doctrine of peri delicto given the precious disregard of the statutory provisions by both the parties and the judicial officer, the court applied the doctrine of peri delicto in equal fault, concluding that neither party could seek the benefit from their mutual fault, could not claim the refund. The ruling, the outcome, the High Court dismissed the writ petition, declining to interfere with the impugned order and set aside the refund sanction. Direction: the revenue is directed to issue appropriate directions or instructions for the scrupulously following the mandate of the statutory provisions while dealing with the registration of both the entities in the case of amalgamation, and take the appropriate steps within the time frame as soon as the judicial officers becomes aware of the amalgamation. Liberty: the High Court did not explicitly grant the liberty to the revenue to initiate the fresh proceeding, but the dismissal of the petition upheld the revenue's action of setting aside the refund. A very important case. You have to maintain timelines and understand that partial refund and partial transfer are bottleneck in this case. Thank you and subscribe to the channel for more such videos.